Hello, everybody. I'm Gemma Morgan, a barrister here at Quadrant Chambers, and I'm delighted to welcome you all, both in person and online, to this Quadrant Chambers London Maritime Arbitrators Association panel discussion about the future of maritime arbitration. Statistics released last week show that London handled over 85% of the world's maritime arbitration in 2022. The supervisory jurisdiction and the pro-arbitration stance of the English courts is a major factor in the popularity of London as an arbitration centre. And that is reflected in the fact that in the legal year ending in 2022, 25% of the commercial court's workload related to arbitration. Indeed, in order to underline commitment to London as a premier arbitration centre, the Law Commission has recently concluded a 2-year review of the Arbitration Act and published just last week its final report and draft bill for amendment of that Act. And so it's very appropriate that at the start of London International Shipping Week 2023, we look to see what the future holds. Now, I'm very sure that you will be familiar with the work of the LMAA. It's the powerhouse of London maritime arbitration. It was founded in 1960, but its roots go much further back than that, over 300 years through the history of the Baltic Exchange. In 2022, LMAA arbitrators received 3,193 appointments, and it made 420 awards in the maritime sphere. So any discussion about the future of maritime arbitration must have the LMAA at its heart. Now, to help us explore where maritime arbitration in London could and should go in the future, I have a very distinguished panel of speakers today. We are especially thrilled to welcome Professor Sarah Green, Law Commissioner for England and Wales. Sarah is the hottest guest in town this week, fresh off last week's publication of the draft arbitration bill and the final consultation on the Arbitration Act, which project Sarah chaired. So thank you, Sarah, for joining us, and in particular for publishing last week just in time for our session. We then have John Elvey of the LMAA, full-time arbitrator for the last 5 years and LMAA committee member, and known to many of you, I'm sure. John was at Insinco for 40 years and brings a wealth of experience to this discussion, both as a user and now provider of maritime arbitration services. Next, we have Nicola Cox, who is Head of Defence Claims at West of England. We are delighted to have Nicola with us to give us a view from the coalface and some insight into what clubs and members are looking for and need from maritime arbitration. We then have Andy Preston, founding partner of Preston Turnbull, and well recognised as one of the world's leading shipping lawyers. Andy has acted for many years for clients in the maritime sector, acting across the full spectrum for international banks, oil majors, ship owners, insurers, charterers, and cargo interests, both nationally and internationally. And last, but by no means least, we have Nigel Cooper KC at Quadrant Chambers. Nigel is a barrister with over 30 years' experience in shipping, energy, and international arbitration, appearing before tribunals worldwide. In addition to his practice as counsel, he was appointed as a Deputy High Court Judge, I think 2020, and sits regularly as an arbitrator. So that's our panel, and we're going to focus on 3 topics today. First, we're going to look at the impact, if any, of the Law Commission's review of the Arbitration Act and proposed amendments to it on maritime arbitration in London. Secondly, we're going to look at the pros and cons of maritime arbitration procedure for its users in the maritime industry and how its offering can be improved if shortly. And then finally, we're going to come on to consider how maritime arbitration in London will adapt to the challenges of the future. Now, we would very much like this to be an interactive discussion. So please, if you do have any questions, raise your hand as we go through, and we will try to deal with them. And similarly, for those of you who are joining us online, please do pop your questions into the question and answer facility, and again, we will try to get to them. Looking first then at the Law Commission draft bill. Sarah, you just published the draft bill, the amendment to the Arbitration Act. You chaired that project. Now, I think the current 1996 Act is, I think it's fair to say, regarded as a success, and it's a key aspect of the attractiveness of London as a centre for dispute resolution. But I wonder if you could please talk us through the key changes which you proposed in the draft bill, and perhaps just as importantly, what are the key aspects of the Act which are not going to change?
Yes, of course. So we began the project on reviewing the 1996 Act with a very clear idea that it was indeed and is indeed a statute that works incredibly well in the main, that is very well regarded. And one of the things that is always at the forefront of my mind as a law commissioner is to avoid breaking anything in trying to reform something else. So I would say of all the projects that I have overseen in recent years, that was one of the sort of keenest concerns of mine and of my team was not to break the Arbitration Act in trying to improve it. That said, we felt, and when we spoke to, so for those of you who don't realise, the Law Commission is a consultative body, so we do not make changes that are simply based on our internal team research or our team ideas. And I certainly, as Law Commissioner, can't just say this is how I want the law to be, much as sometimes I might want that to be the case. We make proposals, we consult even to get to those proposals, and then we consult on those proposals. So we have heard from as many quarters of the arbitration community as we could speak to. And where that brought us to was there were just a few parts of the 96 Act that could be tweaked, really. I don't think there's any dramatic changes. I mean, do tell me if you think that it is otherwise. But in this report that came out last week and in our draft bill proposals, they are minor tweaks or clarifications or making in statutory terms express what is already a practice or a custom, and thereby, of course, providing certainty to the users of that law. So now here's a test for my memory on a Monday morning. What did we change, or what did we sort of make an active modification to? That is duty of disclosure, immunity, arbitrator immunity, summary awards, challenges under Section 67. I'm smiling because that was probably the most controversial of the points that we consulted on. Governing law, that was a tricky one. Court support of arbitration proceedings and emergency arbitrators. What did we decide not to look at? I mean, I'm conscious of time. I'm happy to elaborate on any of those in response to questions. I think the most important thing that I would like to mention just at this outset now in terms of what we didn't do, because we received such a strong consultation response on this, was discrimination in arbitral appointments. And in essence, that was something that we felt as a team, we really wanted to help the arbitration community push forward in reducing discrimination in arbitral appointments and in thereby increasing diversity. Ultimately, there were several reasons why we didn't do that. Mostly, I think that the principal one was really that any changes that are made are probably better put in another statute, rather than trying to talk the Equality Act by the sort of almost backdoor way of doing it through the Arbitration Act, we just felt was not really appropriate. And there was a lot of rabbit warren type inquiries that didn't really fit within a reform of the Arbitration Act. So I'm not ruling out the Law Commission looking at this in the future in a slightly different context. But as I said, we felt that really within the Arbitration Act constraints, that the very sort of sensitivities and the difficult questions that arise in terms of remedies, in terms of dovetailing with the Equality Act was just not really appropriate to do through the Arbitration Act. I am happy to continue. I'm aware I've spoken for quite a while, so I'm looking at Gemma.
Well, thank you, sir. Well, what I might just do now is look to Nicola and to Andy, because you're perhaps most of the coalface in terms of dealing with the practical implications, and ask you for your views on the changes, whether they're welcome or not, whether or not they go far enough. Andy, perhaps if you'd like to start.
I'll be delighted. I think as Poonam said when she was stealing our thunder in a paper last week, if it ain't broke, don't fix it. And I think we all thought the Arbitration Act worked, and where it didn't, the LMAA stepped in with changes that helped us run arbitrations in a sensible way. So I don't think there's ever much wrong, and I think the Law Commission recognised that when they made some minor tweaks. When I looked at it and read it, I chopped my thoughts into 3 bits. Ones that I thought were sensible, ones that I wondered why we needed them at all, and then one bugbear of mine that's being missed that really irritates me. The sensible bits first. Section 67 on the jurisdiction appeals was a very sensible change, and I think that was a smart thing to do. I was delighted that you didn't pick on section 69, because I'm horrified that some of the people who responded thought that we should scrap section 69 appeals altogether. And whilst in some arbitration forums, that's exactly what they do, there's no right of appeal. One of the strengths that we have in our business is that there is a safety net. People get it wrong. People make mistakes, and there needs to be a right of appeal if it's obviously wrong or open to serious doubt whether the tribunal did get it right. And so I'm delighted that section 69 remains unaltered. I think the governing law section is a sensible change. It just makes it clear where we're litigating and what law we're litigating over. Some of the changes that, from a practical point of view, I question whether we actually needed, goes to summary disposal and emergency arbitrators. On summary disposal, I have spent years either prosecuting partial final awards or defending them. And there's always been a right under section 33 to make that application. That's exactly what the wording was there for. So will it shift the dial for us on the coalface? I don't think it will. We will still, where one's got a hire claim or a freight claim or a demurrage claim, you're still going to make the applications for a partial final award. The right's always been there, and I just wonder on a practical level what the new summary disposal regime is going to add to what we already have. Emergency arbitrators. It's a right that's always been there, and I've never used it. In fact, in my old firm, I wasn't aware of anyone ever using it. I did a straw poll amongst my colleagues in Preston, Turnbull. Nobody's ever used it. Nicola and I were chatting about it. She's never used it in the hundreds of arbitrations she's been involved in at the club. So, and there's a reason for that, that in a truly urgent situation where you need to get a surveyor on board a ship, where you need to secure a cargo, where you need to take very urgent action, the default setting's always been to apply to court. The vassal orders you get from the courts to get a surveyor on board are nice with a nice penal notice. People take notice of them, people react, you get them very, very quickly. And I do question whether the emergency arbitrator regime is ever going to fly until the court simply slam that door shut and say we're not going to be entertaining any of these emergency applications. And I suspect that won't happen. And my final bugbear is in relation to appointment of arbitrators and the default setting of sole arbitrator, which was identified as a problem by the LMAA some years ago when they flipped it to 3 arbitrators. And the reason why is where you have a recalcitrant respondent who's just not going to engage, and they're normally overseas, the whole process of trying to get them to agree an arbitrator is painful. When they don't, and the application to court to appoint an arbitrator, it wastes so much time and so much cost. And without the LMAA rules being incorporated, that's exactly what you've done. You've got thousands of pounds of wasted costs and time just to get an arbitration tribunal afoot. And I think they missed a trick by not actually switching it to 3 arbitrators as the default, because if the respondent doesn't respond at that stage, you're into section 17 territory and you can appoint your chosen arbitrator as sole. And the whole idea of this is just to get it up and running, to get the tribunal in place. I think they missed a trick on that. But broadly speaking, from my perspective, mostly sensible changes.
That's some positive feedback, Sarah. Just in terms of Andy's missed trick, is that something that you considered with his point about increased costs?
Yeah, it wasn't something that we heard a lot on. And I think one of the things about this project is, of course, there are so many different types of arbitration. And it was actually quite surprising to me that we got some really polarized responses to some of the things that we suggested, you know, in relation to, well, say section 67, I'll take that one as the one that's been discussed a lot. You know, some quarters of the arbitration community said to us, you absolutely must change this. It's ridiculous. It doesn't work as it is. It leads to bizarre results and very expensive results. And then other people said to us, you absolutely must not touch it. If you do that, you will break arbitration. So I think one of the things we were very sensitive to was that there are so many different requirements across different arbitration areas and sort of families, if you like. So some of the changes that were suggested to us, we always erred on the side of not changing it unless we were absolutely convinced that it really needed to happen for a broader range of arbitration interests. So I think that was probably the answer to that one.
You could have shouted louder.
I could have shouted louder.
Nicola, what about you? What are your thoughts on
I think, first of all, to echo what Sarah said in the statistics, is really arbitration LMAA for P&I clubs in particular is a fantastic thing. If we were restricted to court, and we would have, at the moment, our claims handlers can informally appoint arbitrators done by email. You don't need formal service as a jurisdiction, issue proceedings, all of that we don't need to do. And the vast majority of our charter parties we see, I handle defence claims mainly, is 80–90% is still arbitration. It's still London arbitration. And it would be a very different, I'm just trying to think of our claims department, a very different shape of animal if we had to issue proceedings and court proceedings every time. So first of all, a big thank you, a big tick for London arbitration. It's easy to forget that if we look into the detail without stepping back and thinking the overall shape. So that's great. Vis-a-vis the changes, I echo what Andy was saying. I'm glad that the Section 67 challenge has been sort of slimmed down a bit, so they can't have a complete dress rehearsal, but the possibility is there. Ditto Section 69, I think it's good that that hasn't been changed, and I think the way that leave to appeal and the High Court review of that seems to work quite well. So we've had a few well-known cases, and also it gets some publicity if it does appeal. Aquafaith, other cases really make case law change. So there is a possibility of appeal, but it is quite limited. And also the Section 44 court powers, that's also very useful. I don't think I was really very aware of them until you get a case where you really need it. West of England's case, Moscow Stars, where the ship had been sitting there for months with millions of dollars worth of oil on board and millions of dollars worth of hire. We apply to the court, sell the cargo, and then argue about the money rather than the ship being in the charter party and the price of the oil fluctuating. The only possible, I think the thing I'm a little bit disappointed about is the impartiality / duty of disclosure. So impartiality is provided by in the Act in Section 33, and of course Section 24, the parties can apply to remove an arbitrator. That's been left as is, which is great. Duty of disclosure, so you recommend codifying the common law so that the arbitrators need to disclose any circumstances which might reasonably give rise to justifiable doubts as to their impartiality. And as the summary paper says, that's partly brought on by the Halliburton and Chubb litigation. I'm just a little bit unclear about you're still leaving it subjective. The arbitrator, he might or she might reasonably give rise to justifiable doubts. I think special members over abroad, probably in the Asia Pacific region, can find it quite strange that there can be some distrust, especially they see the arbitrator comes from one chambers, the barristers might be the same chambers. I think it's very alien to them, and I think it'd be better to, like you were saying, it's good to codify the duty, but actually state, I can see it could be difficult, but the sort of circumstances that should be disclosed. For example, it says the Law Commission should make their own inquiries if necessary, but actually like the percentage of appointments from a particular firm or by a particular party, I think there is no harm in perhaps outlining the type of criteria rather than leaving it completely. Well, my fear is it's not going to change anything. I think it does need to change. So that's my main comment on that.
Right, I've replied to Sarah on that. Did you think about giving more specificity to what was required from arbitrators?
Yes, we did. One of the reasons we went for the justifiable doubts, the sort of codification of the Halliburton argument, was because, again, comes back to this different arbitration areas have different practices, and we were told a lot about overlapping appointments, which in some quarters are incredibly common. In fact, that's the sort of usual situation, and in others where an overlapping appointment would actually, it's so unusual, or there might be other circumstances which mean that in itself would give rise to justifiable doubts. So we decided to go with that wording to cover all of those bases, so that only if you were in the circumstances where it would give rise to justifiable doubts would it then trigger the duty of disclosure. When it comes to outlining specific lists in a statute, I'm sort of going to pass the buck here in that what my job as a law commission is to talk to Parliamentary Council and say, we want the statute to do this. And then Parliamentary Council are just these incredibly, to me, just amazingly talented people who take what you want the thing to do and put it into words, which seems very easy, but really, really isn't. And sometimes we take advice from Parliamentary Council that actually, if we tried to put X, Y, and Z in a statute, there are various reasons as to why it might not achieve what we think it would achieve. And one of the problems with putting lists in a statute is, of course, it ossifies a set of circumstances that we might not necessarily want to ossify. So what we are hoping, and we do this, we've done this in other projects, is by putting our reasoning in the report itself, is that when those, what is in the statute is being interpreted in a forensic sense, that reference can be made, and in fact, is sort of formally made quite often to the report behind it. So, I mean, I concede that that is a bit of a fudge and doesn't provide the certainty that some parties would want. But of course, it's that sort of perennial tension between certainty and then losing flexibility and not catering for all the different types of arbitration. But I do take the point.
I mean, you don't have to be a list. It could be in respect of the arbitrator's background, professional background, whatever. You could sort of put the context rather than the list of the items might be helpful. Yeah,
little in terms of practicalities, I'm curious, Nigel, John, as arbitrators, is it going to change your approach?
Well, I take a slightly different view from Andy on the power of summary disposal, because I actually do think it's valuable to have that now codified within the statute, because I entirely accept Andy's points that there are various types of circumstances where you can go very quickly to a partial interim award. Freight and hire claims are the marriage claims sometimes are very clear examples of that. But I think it's valuable also to have the wider power that in disputes where perhaps traditionally partial interim final awards aren't quite so common, the new summary disposal power, combined with, for example, the power to deal with hearings on documents, will be a valuable addition. I think the two things that are important around that, though. First of all, is that once the power's there, arbitrators have got to use it. We've had a statutory power to dismiss arbitrations for inordinate delay in the prosecution of the arbitration for quite a while now, and it's a very rarely used power. And the general view is that the result that applications are saving the clearest possible circumstances unlikely to succeed. So I think having the power is really important, but I think it's also got to be used.
John, in terms of duties of disclosure, is that going to change your approach at all, do you think?
Good morning, everyone. My personal approach, rather than hiding behind any generalizations, is that, as the International Bar Association says in its guidelines, and the IBA guidelines are the closest we have to conflict rules, as they say there is a kind of carve-out for maritime, sports, and commodity arbitrations, because everyone in those worlds knows that the pool of people involved is very small. I probably either know everyone in this room or I know where you come from, as Coco Gauff said in the tennis at the weekend. You know, I've grown up all my working life knowing Quadrant Chambers, or before them 2 Essex Court, knowing the West of England, and knowing Andy's firm and his predecessor firm. And everybody is involved with everybody else. Now, the Law Commission has said, and the IBA has said, that there is now no statutory duty to disclose how many appointments you've had from a particular firm. If someone asks me to do it, and they do, I would probably be quite foolish not to do it on a matter of courtesy basis, voluntarily. But I do receive all my appointments from a very small group of law firms and clubs with a few outlying appointors. So it would certainly add to the burden. Whether it actually creates an obligation, whether it shows reasonable grounds for justifiably doubting my impartiality, is something which has now been ruled on. And I personally have my doubts about. My own sort of guidance is what a very wise arbitrator said to me when I started, which is, if you feel uncomfortable about something, if it's on your conscience, then think very hard before you accept. Now, that may include that, and it may go further than that. And I did something recently, which, if I told you about it, you may think I've given up a very big appointment, but I just felt it didn't feel right. So I said no. So I think it is very much horses for courses.
Because of the identity of the appointer.
Because there was someone, no, more than that, because there was someone buried deep in the papers, which for some reason I was given when I was asked if I wanted to be the arbitrator, whose name I recognised, who used to be not only a client a quarter of a century ago, but someone I knew quite well. Actually, it was a family member, and I just felt the litmus test, what I really want to get involved, and I said no.
I'm going to throw it open to those in the room and indeed online. Does anyone have any comments on the duty of disclosure? Indeed, any of the changes to the proposed changes to the Act? Please be gentle with Sarah if you do.
You clearly got it right.
I was going to say that's a resounding vote of confidence. Well, in that case, even though everybody is very, very happy with the draft bill, let's hope it makes its way through Parliament. Well, then let's move on and have a look at the pros and cons of maritime arbitration in London as it stands. Now, of course, despite its premier position as the centre of maritime arbitration, London, of course, faces competition from overseas jurisdictions. And in order to retain that premier position, but we need collectively, I think, to identify first what user demands are, and then second, to give some consideration to how we meet them. Now, you might think that it's quite easy to identify at least a high level what users want. So they want a cost-effective and efficient service with top quality decision making. Finality of outcome is important, and the supervisory and ancillary jurisdictions of the court, which we've been discussing, are there to be used in limited but appropriate circumstances. And I think it's probably fair to say in the modern world as well, users want an easy to use and accessible process. So that sounds great. But the real question then, I think, for the panel is whether or not our current system meets all of those needs. And if not yet consistently, what more can we do to ensure that it does? Now, John, I'm going to start with you. I think probably it's fair to say that one of the great attractions of the LMAA procedure is its non-institutional nature, its flexibility, and the fact that it can often be party-led in terms of timetabling and pace of progress. But one issue which we all know comes up, mentioned often, is costs. Arbitration was some time ago, I think it's fair to say, seen as a cheaper and quicker alternative to high court litigation. But we all probably have experience of arbitrations that drag on with the concomitant costs that go with it, huge exercises in disclosure, etc. So my question for you is, what do you think arbitrators can or should do in order to improve the process for the parties, in particular from the point of view of keeping costs down? And I'm going to ask you, if I may, when answering that question, to just perhaps enlighten us a little bit as to the pressures that are on arbitrators. So we hear a lot from the users, but enlighten us a little bit there, if you wouldn't mind.
Well, if I'm honest, I would probably start, whether or not it's a popular comment, by saying something I said at a seminar in Piraeus a few months ago, which I called the avocado principle, and I produced an avocado in my breast pocket, which maybe was not the best thing to do, but I did it. And the reason I did it is that avocado is the same in any language, like iPhone. But the serious reason I did it was that I said that after the tender period of 5.5 years in arbitration, I was getting besieged by messages written on the avocado principle, which is one side or the other writing 25 paragraph messages to me or the tribunal saying, dear tribunal, it is clear that our opponents have the IQ of an avocado. We are appalled, outraged, and astonished at their attitude. And then they would then spend a dozen paragraphs telling me or us why they were astonished and outraged and how ridiculous and stupid it is that a well-known and senior law firm practitioner, a P&I club, doesn't have any sense, which would engender the same response from the other side. Now, I probably used to do this or encouraged my team to do this in private practice. I hope I didn't. Certainly when I started, there was no electronic mail, so it wasn't easy to write long messages. Now I can dictate into a microphone. I mean, I can't even use a microwave, but I can dictate into a microphone that takes my words down pretty accurately. Or I can dictate into my phone and send an arbitration award to someone in Australia to get it typed. So it's much easier to send long messages. And on Gemma's point, I think costs at the party end are not helped, not so much by procedure, because the procedure is pretty good under the second schedule and it seems to work, but in the way that it is abused because of personal insults and complaints and all the rest of it. The best messages we get and the ones which result most often in our giving swift, I hope, effective, I hope, correct, I hope, responses are those which say, dear tribunal, the opponent says this, we say this, we are right for the following reasons, and this is what we'd like. I think we used to do that more 30 and 40 years ago because we had to. But I think I'd like to see a lot more of that at the party level.
Well, I was fair to say that good case management can certainly affect the costs of an arbitration, as well as user satisfaction with the process. Nigel, you sit as both, you sit as an arbitration, obviously appear as counsel. What is your experience in how case management is generally being undertaken these days? Do you think it can be tightened up at all, leaving aside the parties restricting their approaches to the arbitrators to what's necessary? Can and should maritime arbitrators go further to tighten up the process?
Well, I think I would agree with what John's just said, that I think the second schedule of the LMAA procedures broadly sets a workable and efficient timetable. And I think that was a major step forward by the LMAA. I think there were justifiable criticisms perhaps 10 years or more ago that too many arbitrations suffered from extensive delay in actually moving the dispute through to a resolution. And I think that has changed. It's changed partly because the LMAA has recognized the problem. It's changed also because it is a sophisticated user base. And so what they've done, they've started it, they've looked for, they choose arbitrators from whatever background who they know will move arbitrations forward, will take a robust approach at looking at the 25-page letter and saying, well, it's the last paragraph I need. It doesn't tell me what I want. This is what I think is the right approach. I think we're also seeing now, and I think this is a good thing, arbitrators recognizing that sometimes you need to step back from what the parties have both put forward as proposals and actually just ask yourself, is there a better way? Should I be looking at something else? Should I offer an opportunity for alternative directions? I think what one's got to be very careful about that is that tribunals can't be seen to be dictating the progress of the arbitration. You've got to remember that arbitration is a consensual process and that the parties have to be given a fair and reasonable opportunity to be heard. I mean, otherwise, you need to avoid a situation where there's going to be a challenge to an award, either before the supervisory jurisdiction under Section 68, or perhaps later on, more catastrophically at the enforcement stage. So as I say, I think tribunals can be proactive, but they've got to do it in a way that essentially cooperates with the parties, but recognizing that at the end of the day, you've got to make a decision.
It's a very fair summary. Nicola, from a club point of view, do you agree with the balance that Nigel's saying ought to be struck there?
Well, I mean, absolutely. Coming from Nigel was saying, is there a better way? And it struck me during lockdown, we were having to have hearings remotely, that actually maybe one way would be to be more agile in that respect and think about what is the, you say, step back. The parties got their 25-page submissions on each side and actually step back. What is the best way? Maybe a short 1-hour meeting online to discuss, thrash out the issues, a bit of thought-provoking perhaps limit, I mean, I'm a great fan of, doesn't happen very well, intermediate claims procedure, small claims procedure. For small claims, you limit the number of words, you limit the document disclosure. I have to say is the item most often that breaks our budgets. So if you're from a defence club, a bit of commercial knowledge here, I don't think it's particularly news to any other club people watching, but our average premium per vessel for defence century is under $10,000 a year for any number of disputes, 365 days a year. So $10,000, you can see how easily, so costs, P&I obviously get much bigger claims, but it is very much in the heart. And yes, clubs have a responsibility. I think tribunals do as well. Another thing, if parties are making unreasonable applications or building up the workloads unnecessarily, and there's lots of powers in Schedule 2, as you both mentioned, as actually making a cost order there and then and having the cost paid there and then, not kicking it down the road. Oh, mañana, we'll do it when the whole case is finished. And sometimes you forget about it. Actually, there and then, if somebody's had unreasonable conduct, and Schedule 2, paragraph 13 says that tribunals actively consider ways to make the arbitration as cost effective and as efficient as possible. And Schedule 2, paragraph 19, tribunal can make cost orders about unreasonable and inefficient conduct. Again, and obviously unsealed offers, etc. I think it's a bit more, it is active management. I agree with you. Different arbitrators have different styles. It's not always that easy for everybody, all the users, to know. Perhaps I'm not in the know exactly which arbitrators will have the more proactive style. I mean, it's trial and error, perhaps expensive trial and error, painful trial and error. So what am I, sorry, my phone distracted me. So it would be good to have more use of the powers and interim cost orders that are payable there and then. There's nothing like a bit of pain, a little, and also for the club, if we're not on the ball and we're not alive to the arguments the solicitors are raising, which we should be, there's nothing like a cost order saying, hang on, what's happened here? And actually reappraise the way the case is being managed. ICP I've mentioned, I think it's a fantastic procedure. It limits the parties' recoverable costs and the tribunals. It limits, there is a possibility of appeal. Oddly, it's stated that it's more generous right of appeal than there is under Section 69 of the Arbitration Act. You don't have to show the decision's wrong, but perhaps that'll be tightened up. Only exceptionally a hearing, but there is, in some ways, it's imposing a discipline on the parties. Yes, the parties can argue what they like, but if they have to bear the costs, if they're being unnecessary or unreasonable, then I think that's a really good thing. And I think it will actually help, if that was done more often, it will actually help to reduce the costs that are spent in cases in arbitration, because it will make everyone wake up and realise what's going on, smell the coffee. The only other thing I say, security for costs, my plea would be, rather than arguments, I'd much rather have clear guidelines or both parties provide security for costs rather than argue in applications about whether security of costs should be provided or not. Let's just forget that. Let's get to the real issue, provide security for costs and get on with the arbitration. So that's just my practical pointers. Probably easier said than done, some of them.
A request for more discipline, a little bit of pain as we
Yes.
go along.
And there's nothing like visible pain of having to pay.
Andy, out of everyone here, probably you're in the position to appoint arbitrators the most. What difficulties would you say that you find in doing so, and what do you think could be improved from yours and importantly your client's point of view?
Anything I say now, I say with love. And to all the arbitrators who are sitting on panels that I'm involved in, I love you all. But a serious point, I'm a strong supporter of the LMAA. I always have been. I think by and large it is an exceptional dispute resolution mechanism. One only has to step into ICC to be scarred for life, and when one gets back to the home of LMAA, you suddenly feel warm and fluffy again. But there are things we can learn, and the LCA do a lot of good things when they run arbitrations that we could perhaps learn from. As to appointing of arbitrators, just right from the get-go, there are some issues I have on availability, on delay, both by the tribunal but also by the other side, a lack of case management, lack of control. There are some diversity issues which we'll come on to, and it's the breadth of skill sets. Now, just breaking those down, quite rightly so, we have an LMAA list of members, full members. we have an aspiring list, and we have supporting members. And there is a feeling that the full list is the kite mark, that they are the cream of the arbitrators. And so, however, whilst one can appoint whoever you like as an arbitrator, there is a general default setting to look at that list. And I was slightly perplexed when I was trying to appoint an arbitrator a few weeks ago, and the first two turned me down, which doesn't happen for a long time, which suggested that they were quite busy. It wasn't on the grounds that John said of bias, because I haven't paid them enough. It was simply that they were too busy. And that struck me that there's a lot of busy people in this room, and that probably filters into a lot of the other issues that I see, because there doesn't seem any thought process at the beginning as to how this reference is going to progress. It is very much a reactive approach from the tribunals. You look at the LCIA, and they would, right from the get-go, would get a procedural order out, and you will stick to that procedural order. And the arbitrators will be interventionists, and arbitrators in this room may disagree, but I suspect you don't really look at the pleadings, you don't really bother about the case until an application is made. And I am a fan of front loading a case, because as a general rule of thumb, the longer a case goes on, the more expensive it's going to be, and the more dissatisfied everyone using it's going to be. And if you're acting for a respondent who has not put up security, your job is to delay matters for as long as you can. So it would be an unusual situation where both law firms, both counsel are gagging for it and can't wait to get on with the reference. So if you've got a mixture of delay, and it's a question that arbitrators should ask themselves at the beginning, and a procedural order is quite a useful aid memoir, that where is this case going? When am I going to be sitting? And can I really be available? Two recent cases where I was looking to fix a 5-day plus hearings, there was a 6-month delay because the arbitrators were not available. One of the 3 were not available for that period of time. Now, I don't think that is doing our clients a particularly good service. And you need to have proactivity from the get-go. I've always been a huge fan of interventionist approaches by arbitrators, where you will have a very early case management conference and you will thrash out some of the issues. And being on top of the facts, you will understand that these extravagant disclosure requests from one side are just hell-bent on driving up cost, irritating the other side to posture for a better settlement. And I would love to see a far more aggressive case management to say, we're not doing that disclosure, we're keeping it very narrow, because inevitably it's always the same 25 key documents on every case, whether you start with 100,000 documents on some e-disclosure exercise. So I'm a huge fan of arbitrators being available, keen, and driving the case from a very early stage. Learn from some of the good things that the LCIA do in getting a case to a hearing quickly. I say the diversity on the options of appointments is something we will come on to when we look at the future. And then it's the breadth of available talent as well, that I have no doubt that every arbitrator in this room is capable of dealing with most of the arbitration subject matter that we're involved in. But I suspect you're all starting, when one talks about CII or hedging losses or fuel contracts or super yachts, you're starting from a fairly low start point, and you're being educated as the case goes along. And there is some merit in having a broader cross-section of talent available. And so how do you achieve that? Well, at the moment, it is, if we start from the point that the 4 members are the default setting, then that's quite a limited pool. It puts stress and pressure on availability and speed and case management. So what do you do? And I suspect every single aspiring member can and should be made a full member very quickly, which would widen the pool. And I suspect most supporting members are more than competent to become an arbitrator. I was appointed in LCA arbitration, and it wasn't that difficult. If I could do it, anybody could do it. So I think it's a fabulous system. I think the LMAA does a fabulous service, but as a friend, it could do better.
Well, Andy's thrown down the gauntlet there a little bit in terms of John, I'm going to ask you to come up. We heard Nigel's thoughts on the importance to balance in terms of proactivity with being a consensual process. Andy, Nicola, I think to some extent are calling for more active case management. What do you think on that?
I think it's a very good point. Arbitrators, if they get busy, get busy. There's an old job. If you want a job done, give it to a busy man or woman. So the busier ones often get busier, just like anything in life. The best law firms, the best solicitors get busy fast. Very often, I don't hear from the parties for a long time. We don't hear from the parties for a long time. That's either sometimes because they've gone off to try to settle it, or one of them has got second thoughts, maybe even the claimant, about doing certain things. There's a lack of funding, something behind the scene. I know this because it was what I was doing. And then the claimant comes to us after 2, 3, 4 months and says, nothing's happening, we want orders. At that stage, if we get too relaxed about imposing a timescale, we are not being active. Whether you call it proactive or reactive, we're not being active. More difficult are the times when the claimant themselves doesn't come to us for a long time. It may well be that it will be one way round it to issue timetables at the beginning, but that's what the second schedule is there for. I certainly, on a personal level, if someone asks me to impose some order on a drifting procedure, we'll try and do it. I think there's a big difference between delay and the pace of something. I delayed coming in here today because I was pretty nervous about learning my lines or what I might be asked. And I went to the coffee shop next door and one of you came in and said, aren't you coming in? I said, no, I'm coming now. I was delaying. Now, going slowly or not allowing things to move faster is something we all need to work on. It might take 2 or 3 to tango, but it's something that we ought to be doing. As far as Andy's other, or one of Andy's other main points about the choice of arbitrators, I completely agree. I completely agree. There is absolutely no need whatsoever to appoint me or even consider appointing me for a case about hedging losses if there's someone out there, particularly someone with qualifications, who knows about hedging losses. It means that if I eventually come onto that tribunal, I'll learn a lot as I go along anyway. And if not, you've already got the start of a good tribunal. Remember, to make a very obvious point, that in your standard commercial or maritime arbitration clause in a contract, you can appoint anyone you like. You appoint one person, you appoint one person. If they don't agree, you appoint a third person. But it doesn't say who those people have to be, beyond the occasional reference to being a member of the Baltic Exchange. It doesn't say anything. You can appoint your favorite hedging expert or broker, as I did a couple of times at INSIS. Neither of them had any experience of arbitration. One was a ship manager on a ship management case. The other was a sale and purchase broker on an S&P case. We lost the first case, by the way. But you can appoint who you like. You can appoint each other in this room. So I'm with Andy. I would go for the people who you think do the job in the best way. Now, if you think LMAA arbitrators have the quality and you trust them and you have confidence in them, we'd be very happy to accept those appointments, and we do. But if there's someone else out there, then irrespective of whether they're called aspiring full members or supporting members, the pool out there is as wide as you want to make it. No one will object unless there's some obvious bias or reason. And a default setting is only a default setting. It's only a starting point. That's my view.
Thank you, John. One question which we've had in, which describes a comment rather than a question. It says this from somebody watching. One important reason that London is an important venue for arbitration is because English law is still considered the leading choice of law in the shipping world. But there are an increasing number of mixed arbitration clauses of English law and non-London arbitration venues. Nigel, I'm going to ask you 2 questions that are arising out of that. 1, do you think that's fair? And 2, what is it that we as arbitration specialists and practitioners can do to ensure that London, to keep London at the forefront, to ensure that English law clauses are what people choose?
Wow.
Briefly,
If I can, right. Well, I think I would certainly agree with the comment about English law as the choice of the substantive law of contract. I mean, it offers certainty, it also offers flexibility, and we're seeing that in many respects in the way that while legislation lags behind, the common law is being used to deal with, for example, the allocation of risk in the context of CII, the situation that we have arising out of Ukraine, and so on. So I think that certainty is I would agree with the comments in that respect. I think there's another slightly different point which is also important, which is that quite often you have multifaceted disputes where you have proceedings, arbitration proceedings in London, but you might also have high court proceedings in Singapore or an arbitration in Singapore. And I think it's one of the strengths of London and of English law that the systems remain complementary. There are some really interesting judgments from the Singapore High Court, for example, comparing English law and Singapore law in relation to misdelivery claims. And you can just see how the authorities that have been used have developed the law in both jurisdictions. And I think that helps makes the strength of English law. I think the importance, the availability of a supervisory jurisdiction is also important. And I think it's quite telling that when the SCMA introduced the 4th edition of their rules, one of the points they made in so doing was that the rules were drafted so that if parties wanted, they could operate seat London, venue Singapore, so that they had all the attraction of regional arbitration, but they avoided the fact that there is no right of appeal in international arbitration in Singapore, or there wasn't. I think it still isn't. And you brought in the supervisory jurisdiction in London, and I think that emphasises again the importance of being willing to look at a dispute and say, okay, its seat is London, the substantive contract is English law, the law of the arbitration, certainly going forward, is English law. But where's the sensible place to have the hearing of this arbitration? And so, for example, a number of years ago, I did an arbitration in Johannesburg. It was a 10-day LMAA arbitration. But what it made sense in that context for counsel and for the arbitrator to travel, because all the witnesses and the focus of the dispute was about what had happened in Johannesburg. And therefore, we could deal with it most efficiently that way. So I think that's answered your question.
It is. I'm just going to throw it open to anybody else in the room or indeed online. Yes, I'm going to ask you to wait for a microphone before answering, which is coming.
I can talk quite loudly.
It's just for our online audience. Thank you so much.
Hello, Mike Allen, LMAA Arbitrator. I just want to come back to what Andy said, that there are full members and there are aspiring full members. So make all the aspiring full members at a stroke. There are guidelines in the LMAA rules as to the requirements to be an aspiring full member and a full member, so that you, the consumers, can see what the experience is. Generally, when aspiring full members apply for full membership, and there's a formal process there, what reduces their chances is the number of appointments that they have had. So if an aspiring full member has had 20 appointments over the last 5 years, that's not very much experience. The answer to that, and this comes on to diversity, is that it is for the users, the solicitors, the clubs, etc., to encourage by appointment those who may lie on the fringes. But unless they get the appointments, and I would say that the LMAA has a very, very limited option in relation to appointment of people to arbitration in small claims procedures, etc. If there hasn't been the appointment of a third, there's an option. But the ability to appoint new arbitrators lies with the solicitors and the clubs. And if they don't, the people don't get the appointments, then it's very difficult.
Thank you. That's very helpful. Does anyone else? Yes.
My name is Philip, and what I'm going to say, I'm going to say in love.
A lot of love today.
The biggest risk, because the point which we're discussing is the risk to the goose of the golden eggs, London. And I think one of the biggest risks that I perceive still being attached to a ship owner is the loss of the commercial nature of LMAA by the swelling of the ranks of ex-lawyers, ex-solicitors, ex-QCs who describe themselves as commercial people, which from a shipbroker's point of view, is slightly offensive. I say it in love, doing expert work, I bump into this again and again. I see pleadings which are on their third round, and there is an assumption that the ship owner or the cargo interest or whatever the party has paid sufficient attention to realize and to advise the law firm in what's in there. And there are very obvious things omitted, missing, or misstated. And the fact is that ship owning outfits like I work for, we're busy people. And when it gets thrown to legal, people don't look at things anymore. So proper shipbrokers or managers or whatever aren't going to look at it. Same in the cargo interest. And so if the parties dealing with it in the law firms don't actually have the commercial background, my advice is bring in the experts sooner. Because I have very often come into cases that are in their third round or their fourth round and say, sorry, all these voyage calculations, there's no demurrage. There's another $1 million or $2 million washing around somewhere that somebody's hiding. Oh, and of course the arbitrator is in a tough situation because the arbitrator might be a commercial person, but what are they going to say? You're missing the demurrage, or how are they going to play that out? So commercializing, re-commercializing, salvaging the commercial nature of the arbitration is probably the best thing we can do for the goose of the golden eggs of London.
Thank you, that's very helpful. I think that picks up as well on your point, Andy, a little bit about front loading things and grappling things at the start. I think Ian Gaunt had a question.
Can I make a comment first of all about mixed arbitration clauses? Because I think that these are a real trap for the unwary. It's very, very convenient for a broker, for example, to try to get a deal through on the basis of, let's say, English law, Singapore arbitration. But I think in many cases, the parties don't know what they're letting themselves in for. They're letting themselves in for, if they can't agree on the sole arbitrator, that the arbitrator will be appointed by SIAC. Is that what they really wanted when they agreed to that? They're then going to have a situation where they have an English law obligation and they're going to have no right of appeal in Singapore. So it's a very, very convenient formula, it would seem to many commercial people, but it's a very, very dangerous one in many cases. Can I say something about availability in response to Chris's comment? It's often very difficult at the outset of a case to know precisely how fast the case is going to move. Much of that will depend on the cooperation of the parties. Obviously, you can have a procedural order at the outset, it will be possible, or you can require the parties to stick very rigidly to the second schedule, and we try to do that as far as possible. The range of excuses, which are of course offered for delays by firms, I would say never Preston Turnbull, of course, are absolutely legion, and some of them are perhaps justifiable causes of delay, others are not. We have to make a value judgment about that. But as far as making a prediction at the time you're appointed about your availability for a hearing, I think it's worth bearing in mind a couple of things. One is that 80% of our cases are decided on documents only anyway, so there is no hearing. The parties would have great difficulty in many cases in predicting the length of a hearing at the time they actually serve a notice of arbitration. And in my experience, far more delay is caused by the non-availability of counsel than it is by the non-availability of arbitrator. And the arbitrator's option in those circumstances is to say to the parties, you choose different counsel. And of course, the parties come back and say, oh, but these counsel have been involved in this case the last 12 months, and we can't possibly sack those counsel and move on to somebody else. But we do that sometimes, and I have done that in a very recent case when I'm sitting with a retired High Court judge. So there are no single nostrums which one can apply to these circumstances. You have to trust people with experience of running arbitrations. And frankly, I think that the ability of LMAA arbitrators to run arbitrations rather than to rely on somebody like the LCIA is actually a great plus of the LMAA system. I've dealt with many LCIA arbitrations as well, and I have no hesitation in saying that the LMAA system is much superior. Thank you.
Thank you, Ian. I think all I'm going to say in relation to availability of counsel is no comment. All right, I think that segues us quite nicely into our final topic, which is the question of how London maritime arbitration is going to adapt for the future. We've heard some of the things that users are keen to see. John, perhaps you can give us a little insight into how the LMAA is adapting to the future. For example, these days, the idea of 30 people getting on a plane, flying into London, whilst it's done, perhaps there are other options that people want to explore. How's the LMAA approaching that?
Well, I love getting on a plane and flying into London, and I don't charge people for the flight or the accommodation because that's my problem if I don't want to be here all the time. And I do think, in my old-fashioned way, that it's still very useful in many cases for people to see, look at each other in the eye, whether they're witnesses, counsel, experts, and arbitrators, for that split second of hesitation in an answer to a question. And also for if there's more than one arbitrator, for the 3 arbitrators at lunchtime and in the coffee breaks to have a physical chat, as you say, in real time about things instead of over a screen. That's a personal preference. That's not what I would do or not do. I do think, though, Gemma, that the world has changed forever. I think COVID, talking to my friends in the medical profession, unfortunately, will be with us for decades, like malaria. It's not just going to go away, but it's certainly under control. But I do think it's changed people's thinking, ship owner level, club level, everybody's level. Why should we send the chief engineer to England for a week, especially if he's on a ship and we have to get him off in the Philippines? Why should we send the master? Why should the expert have to be in London or Singapore or Johannesburg for 10 days? And will all the arbitrators be like John Elvey and not charge for everything? Certainly, if the parties come across, they'll charge, and the bill of costs at the end, if we see it, to tax it, to assess it, we see those figures, and they're big figures. So I'm not a fan or a non-fan, but I'm perfectly happy to stay in my office, in my home, and for everybody else to do that and to stay on screen. And I think things have changed in that respect forever. Technology is great. The arbitrators can talk, of course, over the screens at lunchtime, and we do. You and I had a hearing, a hybrid hearing. I thought it worked very, very well. In fact, in that case, the other 2 arbitrators were in London and I wasn't, but it still worked very well. So all of those things I think can work, and they will keep costs down. I also think, and maybe I'm wrong, that when people are in their homes, their offices, the places where they are, they're less verbose. They don't talk as much. They don't go on as much. They keep things down because the technology could drop at any time, because it's less immediate. And I think that has a natural way of limiting the chat.
Nicola, again, as a user, in terms of agility, what more would you like to see?
I think I've said it before, we have the options, we have the tools, we have remote hearings, remote applications, and I think it is just an intelligent use of the now larger toolkit, the more acceptance that important parts of the procedure, some parts you do need to see the people physically, some parts you don't, and just a thought process. And obviously for fairness and for appeal processes, the arbitrator obviously needs to ask the parties, but I propose this procedure, we could do this on documents and this in oral, rather than having the sort of very binary oral hearing for 5 days or all on documents. And I've seen, especially with reference to COVID, awards on documents, even now written in respect of several years ago, and it's so easy to forget the panic and the anxiety that was there in the Chinese ports and what happens. And I think if one could have just had the factual evidence perhaps on a half-day hearing remotely if necessary, or on a screen, just to remind the tribunal and the parties exactly what it was like. It's so easy to forget the nuance of a case, I think, if it is all on documents. But perhaps the legal arguments can be on documents, much like skeletons before a court hearing. So again, I think it's an intelligent use of a now larger accepted toolkit, and where it works and where it won't work. But you have to do it with the consent of the parties, otherwise you might be open to Section 68. Problems in enforcement.
So flexibility and agility.
And a bit of thought about the process.
Yeah. Now we probably can't think about the future without thinking about diversity, and something that Sarah you mentioned, and when you were talking about, well, you didn't manage to get into the draft bill, and why. And indeed, have you found that diversity in terms of arbitration panels, those appearing in arbitrations, is something that international clients are more concerned with these days?
I don't think you can make any generalizations. There are some sophisticated GCs who would be appalled if you just had an all-white male team of lawyers instructing an all-white male team of barristers instructing or proposing an all-white male bunch of arbitrators. They would just question whether you'd lost the plot. So, as it would be unusual if we had not suggested a variety of choices, both as barristers and also as to arbitrators. And frankly, the experts were available as experts as well. That's at the sophisticated end of the clients. There are some people on the other end of the spectrum who could not care less. They just want to win their case, and they just want the best arbitrator available or the best barrister, and diversity and irrelevancy. I think the driver actually comes from people in this room more than anything else, that we as a law firm, we are passionate about diversity. We're aspirational at 50-50 at all senior levels of management, and we approach diversity seriously. And so that permeates into everything we do when we appoint people and we work with people. It would be an unusual circumstance if it would be an all-male team from now on, but that's our choice, not anyone else's.
Sarah, I mean, you were talking about this was something that you were disappointed you didn't get into the bill. Just sort of perhaps slightly taking off your law commissioner hat for a moment, but what do you think that users of arbitration can do to promote and increase diversity in a way that legislation perhaps can't?
Yes, it's something that actually, I mean, aside from the reasons that I gave at the beginning about not wanting to create a sort of dual regime between the Arbitration Act and the Equality Act, and bringing about results that might actually in the long run be worse. The other reason that really convinced us that maybe this wasn't something for the Arbitration Act to deal with was in speaking to all of the stakeholders that we did, we realized that there was already, and you will know this, huge efforts to change the culture, to change the expectations of users. And that was already ongoing. And so what we've tried to do in the report is to say, we obviously at the Law Commission, we recognise that, we're incredibly supportive of it, and that's the way to do it. I think it's really a question of just recognising what Andy had mentioned, thinking more broadly about what you want out of an appointment, and widening the pool really. And with a lot, I mean, I see this on other projects, it's not just in arbitration. Sometimes a lot of it is about optics. I've seen this a huge amount in the recent years of my career, is that sometimes we see these well-meaning publications saying, I'm not talking just about arbitration now, but a particular institution or a particular organization is not interested in certain, demographic pockets. And of course, what that is trying to do is to change the culture. But of course, what it does in that, I mean, it's sort of making a call to that organization or area to be more diverse. But what it also does is it entrenches the feeling of those on the periphery that they feel, yes, you've confirmed it, they don't want me, they're not interested in having me apply. And there is a danger to that. So I think the optics need to change to some extent. I don't just mean in maritime arbitration. Again, I'm talking about all of the sort of participants, if you like, in this process that I spoke to. It's about making it very clear that certain institutions, or all institutions, I suppose, are open to people with the right skills, regardless of what their other characteristics are. So I think it's sort of symbolic and it's the optics to some extent.
John, just thinking about the LMAA specifically for a minute, in terms of Sarah's point about the optics, what do you think is being done at the moment to diversify the pool? and to have one comment in about bringing through future generations.
Yeah, I agree. I feel very I feel very strongly about this stuff for personal reasons, about discrimination and what lies below, just beneath the skin of many people. So I don't need any persuading in it. And for years, I mean, 25 years ago, there wouldn't have been any women in the audience here or on the podium, maybe one or two. I remember the battles we had at Insinco to elect women partners. I had to fight 2 battles, not 1. So I feel pretty strongly about all this. Carrying that through to what the LMAA can do, well, we're not an office. We don't all come in the mornings and stand around the water cooler and talk to each other and see what really happened in the pub last night and who's doing well and who's doing badly. We're not Quadrant Chambers, the West of England, or Preston Turnbull. We're a bunch of very disparate individuals who, in some cases, we've never even met each other. What we're trying to do at individual and committee level is to talk to as many people as we can, not just to widen the gene pool, because as many of you have said, we don't choose the arbitrators, you do, but to let them know that there is a profession, there is a possibility of coming up, if you are a fish in the gene pool, coming up and swimming up and saying, yes, I think I might like to be an arbitrator. I don't know that that was ever put in a properly diversified way, and I'm not just talking about men and women, but now it is. Our president, David Stewart, who's an old friend of mine from Insinco days, goes out and sees people a lot, groups. He told me last week he'd had 20 one-on-one meetings or chats in the last 6 months. Whether that's a lot or a little, it's a lot more than it used to happen. Ben Goss has just been to Hamburg. I will be speaking next week to a group of 25 people in Piraeus. And funnily enough, 70% of them are women, to say, look, you're in shipping. Do you want to know what we do? Do you want to know a bit more about it? Do you want to have it demystified? And perhaps one day you'd like to think about doing it. And I believe that's probably the realistic way to doing it, not to put out slogans. We can't advertise for people. We don't recruit people, but to do it that way. But it must be done with sincerity and it must be done properly.
It sounds like the onus is on all users to think about diversity. Are there any other questions about the future of maritime arbitration?
Isn't part of the problem here? So when there are cases where the client wants to win the case and wants to have the best. Surely, every case is like that. You know, the claimant wants to win, the respondent wants to make sure that they successfully defend. So they want the best. So my question to the tribunal is, how do you think you can go about bringing in people who are not either on the aforementioned list, indeed that is something, probably not on this firing for membership, but increase the diversity? How do you sell to your client? We recommend appointing Mr., Miss, Mrs. X, who maybe has no arbitration experience at all, and everybody has to start somewhere. But I think you, the panel, have far greater opportunities to bring in diversity because of the appointments that you do or do not make.
Did you want to just a quick response?
Yeah, Michael, I completely agree. I mean, it's you have to fish in the talent pool that's available, and we can all look at each other and say, are we doing enough to ensure diversity? I mean, when I was looking to appoint experts the other day, there was not a single woman that was within one of the organisations that I would normally use, who I could appoint as an expert. And so if the talent pool is not coming through the expert world, if it's perhaps not going through the commercial world, it probably is coming through the bar, it probably is coming through the law firm routes. But unless and until the entire industry takes it seriously, and there are as many women seafarers who become experts, engineers, or master mariners, or chemists, then you're not going to have the talent pool that's available. And it's an industry-wide issue. It's not necessarily an LMA issue. You know, I think John's doing a very good job, and so is David Stewart, in trying to move the LMA forward. I thought Sarah Cockerell's comments at the LMA dinner were a little harsh, to be honest. I think a lot has been done, progress has been made, but it's a long way to go.
I'm just going to disagree slightly with Mike in the sense that I agree there is a lot that the users can do, whether it's expanding your own thinking consciously as to who falls within the description the best. Are you only considering people you have historically considered, or are you looking more widely? Looking at what is the dispute? Do I really need to go to the full member I've appointed 10 times for my £100,000 demurrage, $100,000 demurrage dispute, or can I give somebody that first shot who we might not have used before, and who I can sell to the client on the basis that by their background they will be able to do with the issues? But I think we also have to recognise that the type of initiatives that John was talking about by the LMAA, by its committees, are also crucial. And they're particularly crucial if we go back to the point that Philip made about bringing on commercial people who may not ordinarily be exposed to the world of arbitration. I have a slightly different view about clients who don't read draft pleadings, but that's because they need the support. I've spoken to a number of aspiring members who don't come from the bar, don't come from firms, who say it is very difficult, those are solicitors, who say it is very difficult to step back from their full-time career and make them as maybe a shipbroker, maybe an engineer, whatever it is, and step across. And they need to know that there is a support network they can go to. They need to know that there may be events where they can be promoted to the wider audience, to the user audience. They need to know that when it comes to third arbitrator appointments, where it's the tribunal, the existing tribunal that is making those third appointments, it is, you know, they are in consideration. And I can think of one individual in this room who was appointed by quite an experienced tribunal as chair. And then you could see that that individual was being supported by the full members, the supporting members, who were all both experienced arbitrators, through this first arbitration as chair. And I think those initiatives are equally as important, as is looking at the pool of supporting members, because most arbitration clauses don't require a full. If you've got problems with availability, look at the pool. Look at the wider pool of aspiring members and supporting members and say, okay, if time is important, I'm going to find somebody in that wider pool who can do this.
Thank you, Nigel.
I have one small plea on procedural orders number 1. Please, no.
Thank you very much. I think we've reached the end of our session today, and I do hope you've enjoyed it all as much as we have. There's quite a lot of food for thought there. So it just remains for me to thank our panel of speakers for their thoughtful and insightful contributions. Professor Sarah Green, John Elvey, Nicola Cox, Andy Preston, and Nigel Cooper, KC. Just before we finish, I'm going to draw your attention to 2 further events this week. Firstly, the Quadrant Chambers London International Shipping Week debate, debating new horizons in trade finance and decarbonisation, which is tomorrow here at Quadrant House at 9 o'clock in the morning and online. And then tomorrow evening, the Quadrant London International Shipping Week reception at Madison Bar near St. Paul's from 6 o'clock onwards. If you would like to attend either of those events, please do contact our marketing team. And if I can just invite you to say thank you very much to our panel.